This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Well, because Melanie's ill, so I've taken her place. So I'm afraid to put up with me for another 90 minutes. Anyway, in the same way that we had with session 1, I'm delighted to invite you to session 2. This is looking at the Commonwealth Ministerial Action Group, CMAG, Secretary General's Good Officers and Human Rights. And the question is there an enlarging Commonwealth goal? And I'm delighted to invite Amitav Banerji, who is Director of Political Affairs at the Commonwealth Secretariat. After Amitav will be Dr. Karen Brewer, who is Secretary General of the Commonwealth Magistrates and Judges Association, and after Karen will be Dr. Purna, who formerly of the Commonwealth Secretariat and now Director of the Programme for African Leadership at the London School of Economics. And if you want further information on any of them, they are again in the biographies which are available at the back of the room. So with that, I'll hand over to Amitav to kick off the session. Yeah.
Thank you very much, Chair. At the outset, can I say thank you to Stuart Moore and Daisy Cooper for inviting me to participate and to have me join as a panelist for this particular session. It's great to have so many friends in the audience and indeed on the panel. And I know that friends will be kind when they savage people. But it's also a great honor to have two distinguished members of the Eminent Persons Group amongst us this morning. You've obviously just heard Senator Hugh Seagull, and the closing address will be Sir Ron Sanders. I suspect I have the role now of picking up the gauntlet lying on the floor, especially as this conference now coincides with the release of the report of the House of Commons Foreign Affairs Committee, and I do not believe Philip Murphy. I think Daisy was absolutely prophetic in the timing, and it was no coincidence at all. I do value, however, the opportunity to give you a perspective from the Commonwealth Secretariat on the themes being covered by this session, and I do stress the themes at this session are, as was just mentioned, CMAG, good officers, and human rights. I will leave it to my distinguished colleague, the Assistant Secretary General, Steve Cutts, who will be with you later this afternoon to deal with some of the broader issues touched upon by Senator Seagull, including the time frame for implementing a new strategic plan for the Commonwealth Secretariat. It would not surprise you if I were to begin by challenging the title of this conference, The Commonwealth in Crisis. Is reform possible? It is certainly a catchy one, but it is, in my view, an overly dramatic and inherently pessimistic one. I do not deny that the Commonwealth has many challenges to face, but when was that not the case? I would submit that not only is the Commonwealth not in crisis, but it is constantly evolving, reforming, and finding new ways of upholding its values. And I say so from the vantage point of someone who's had a ringside seat in the Commonwealth for quite a long time. And I'm pretty sure that it is not a subjective view, but a well-considered and objective one. Because when I see the graph of the Commonwealth over this period, I do wonder why terms like crisis are employed. To me, the word crisis is reminiscent of two occasions in the Commonwealth when it was truly at the crossroads. One in the 1960s, when the Universal Declaration of Independence by Ian Smith, in what was then Rhodesia, threatened to rip the association apart. The other in the 1980s, when Britain was ranged against the rest of the Commonwealth over apartheid in South Africa. Those were truly difficult days, when the integrity and the cohesiveness of the Commonwealth were indeed in peril. But the talk of crisis in the Commonwealth in 2012 is rather bewildering to me. Let us consider the facts. Since 1991, when the Harare Declaration was adopted, 12 Commonwealth countries have moved from being military ruled or one-party states to multi-party democracy. Some have moved back and forth, but the graph has had an inexorably upwards trajectory. 8 of the top 10 countries in Africa, ranked according to the Mo Ibrahim Index of Good Governance, are from the Commonwealth. Today, Commonwealth Africa is arguably doing much better generally than the rest of that continent in terms of governance and in terms of the inward investment attracted by these countries. Transparency International's Corruption Perceptions Index for 2011 records 9 Commonwealth member states in the top 30 out of a total of 183 countries. The Commonwealth was the first organization in the world to create a CMAG, the Commonwealth Ministerial Action Group, for those who don't know what that acronym means, which I would be very surprised if there were any such person in the room. Despite the desire to emulate CMAG, as well as efforts to do so, no other organization has really managed to replicate a CMAG. Long before others followed suit, it became impossible for a member country to carry out an unconstitutional overthrow of an elected government and not be suspended from the Council of the Commonwealth. CMAG is still the envy of other organizations, and I know because when I visit my counterparts in those organizations, they still marvel with disbelief at how we could ever have secured agreement on having such a mechanism. Some have said heads of government must have been asleep at the time. It is true that CMAG has worked very well when coups have taken place and has been less effective in situations that have fallen short of that, but are nonetheless serious. That is why the Perth Shogun last year gave CMAG an enhanced role, seeking to make it more proactive and preemptive. Commonwealth leaders also sought to destigmatize CMAG by giving it a more constructive and engaging look, though it is debatable how far that has succeeded. For the first time, benchmarks were set out which would be used to assess whether a country is moving in the direction of seriously flouting the Commonwealth's political values and principles. They included the degree to which constitutions are respected, the extent to which fair and credible elections are held in a timely manner and on a level playing field, and the level to which the rule of law and the independence of the judiciary are respected. The yardsticks also include whether human rights are adequately protected, political space is guaranteed for the opposition, and the freedom of the media and of civil society are respected. The agreement on CMAG's enhanced mandate was a major step forward, especially as similar attempts under the 2 previous Secretaries General had floundered. The new dispensation has been tested in the case of Maldives, as High Commissioner Nicholas pointed out earlier this morning. And CMAG has responded in innovative ways, including sending a ministerial mission and consulting several times by teleconference. The Commonwealth Secretary General has also introduced the practice of briefing CMAG at each meeting on his various good offices engagements, even in countries that are not on CMAG's agenda. But it would probably be fair to say that the full test of proactiveness and of preemption is yet to come. And to note also that the stigma that goes with being on CMAG's agenda has not been banished. I suspect that will be very hard to achieve. And some would even argue that CMAG will never serve its original purpose without the fear factor. On the human rights front, the Commonwealth has always functioned on the basis that its role is to promote awareness of and adherence to international human rights treaties and frameworks, as well as to build capacities to strengthen national rights and protection and promotion. The Commonwealth has never had an investigative or monitoring role as such, especially given the substantive mechanisms of the United Nations. However, whenever CMAG has been seized of particular country situations, assessments of the human rights situation in those countries have always been an essential part of CMAG's scrutiny. Similarly, the SG's Good Office's role is also focused on egregious human rights violations. Overall, in the area of human rights, the Commonwealth has made steady progress, including on issues where the membership is seriously divided. such as issues of sexual orientation, LGBTI, and the death penalty. On issues of sexual orientation, those who have grown up in what might be described as Western liberal democracies tend often to gloss over the fact that there is no agreed Commonwealth position on LGBTI issues as such, though the association believes firmly in non-discrimination on any grounds. A large majority of Commonwealth member states have national laws that are not in compliance with international human rights frameworks, almost invariably inherited from colonial times. The Secretary-General spoke for the Commonwealth as a whole when he told the UN Human Rights Council in Geneva last February, and I quote, "Our position continues to be that we oppose discrimination and stigmatization on any grounds, including those of sexual orientation," unquote. He continued, quote, "It is for member states to address incompatibilities between Commonwealth values and mostly inherited national laws in these areas," unquote. The UN High Commissioner for Human Rights, Dr. Navi Pillay, in her recent address to the UN General Assembly, underscored the fact that the UN House is also divided on this issue and that more dialogue is necessary. We have a similar situation in respect of the death penalty, which remains on the statute books of a number of member countries. Many of them have not carried out any executions for many years, in effect constituting a de facto moratorium. Recently, the Gambia executed a number of prisoners on death row. We responded with a statement in which we expressed serious concern at the executions and called on the Gambian government to renounce plans for any further executions. Despite there being a divided house on the death penalty, the Secretary-General has not hesitated to speak out. In both of these areas, sexual orientation and capital punishment, progress can only be incremental and made through quiet persuasion and continued dialogue. There is no scope for censure, and there should be no expectation for overnight miracles. The recent development in one of our member countries, Malawi, calling on Parliament to debate the issue of the constitutionality of retaining anti-gay legislation, is a commendable one. Our record in the field of human rights generally is an active and creditable one, whether it is the areas I have cited or in those of early and forced marriage or disability rights, or the accountability and oversight of law enforcement agencies, or support to countries with the Universal Periodic Review process of the UN Human Rights Council. I believe we have a good story to tell. You may also be aware that the Commonwealth Secretary-General and the President of the International Criminal Court signed a Memorandum of Understanding and Cooperation between their respective institutions in July 2011. And this is despite there being no Commonwealth position again on the ICC. Not every Commonwealth country accepts the jurisdiction of the ICC. So this MOU signaled the former's commitment to end impunity for perpetrators of genocide, crimes against humanity, and war crimes. I know that there was discussion this morning about the Commissioner proposal, and I was greatly delighted that Senator Seagull was able to speak for the EPG here. I would be remiss if I did not mention it myself. The very experienced and wise personalities that comprise the EPG make this proposal in good faith, in an attempt to address what the group felt was a lacuna in the current Commonwealth architecture. They believe that the Commonwealth's role in promoting its fundamental political values would be better served if CMAG and the Secretary-General had recourse to a dedicated source of intelligence and advice, delivered candidly and dispassionately, without being inhibited in any way by the pulls and pressures exerted by member governments. It is known that the proposal did not achieve consensus at Perth. A large majority of member countries opposed the creation of a new institution, which they saw as parallel to the Secretary-General. Frankly, in my view, it did not help for the EPG to call the proposed institution a commissioner, which was seen immediately as a replication and perhaps even a duplication of the UN High Commissioner for Human Rights. The naysayers saw this as an unacceptable ratcheting up of proposed intrusiveness by the Commonwealth, just when they had already agreed to enhance CMAG's role by allowing that mechanism an unprecedented level of intrusion. The intensity of opposition to the idea in the summer and autumn of 2011, first at the High Commissioner's meeting in London, then at the Foreign Minister's meeting in New York, and finally at the CHOGM in Perth, led to the inescapable conclusion that any proposal that smacks of the Commissioner will fail to achieve consensus. Proponents and supporters of the idea have persisted in the view that some new way must be found to supplement the role of the Secretary-General and his staff in scrutinizing the performance of Member States when it comes to upholding the Commonwealth's political values. The House of Commons Foreign Affairs Committee has now echoed that view. But the examination of possible options by CMAG and the Secretary-General, mandated by CHOGM, has not led to consensus on any such mechanism. And to be honest, such consensus is not in sight. The Commonwealth will therefore have to raise its game on its fundamental political values in other ways, and raise it must. The Secretary-General's good offices must, as always, remain the first port of call, and the Secretariat needs to further strengthen its early warning systems and look for holistic strategies to prevent derogations. CMAG must implement its new role seriously. The Commonwealth Electoral Network, now well and truly launched, must make it difficult, if not impossible, for national elections to become train wrecks. The Commonwealth Parliamentary Association must genuinely enable parliaments to play their appointed role in democratic societies. Apologies. The Commonwealth Local Government Forum must give new meaning to grassroots democracy. And even torchbearer civil society organizations like the Commonwealth Human Rights Initiative, and the Commonwealth Journalists Association, and the Commonwealth Magistrates and Judges Association must play their due role. It is possible to do all this, building on the foundations that already exist. As Senator Seagull noted earlier, there has been progress and the direction of travel is the right one. The Secretary-General fully intends to upgrade the human rights promotion capacity of the Commonwealth Secretariat. There is greater connectivity already between the Secretary-General's good offices and the work of CMAG, including the Secretary-General's Special Envoy on Maldives, for example, and CMAG. And there will be greater consultation with relevant Commonwealth agencies, some of which I mentioned. At the outset, I did acknowledge that the Commonwealth still has many challenges to face, even if it has come a long way. Pursuit of core Commonwealth political values requires constant alertness, commitment, and perseverance. It would not be right for me to convey the impression that all is hunky-dory and we can all afford to rest on our laurels. Nurturing values is a constant and unrelenting task, and there are still countries in our midst that give us cause for concern for one reason or another. One country is still suspended from Commonwealth membership, having been ruled by the military for nearly 6 years. Another has seen a contentious and painful transfer of power early this year that has deeply polarized its society. In some instances, we have worrisome issues of perceived human rights violations, serious transgressions against the rule of law and the independence of the judiciary, and of post-conflict justice and reconciliation, to name a few of the challenges that confront us. Our member states know they must live by the rules to which they have themselves agreed. CMAG knows that it must live up to its redesigned role. And we in the Secretariat know that we must constantly hold our member states' feet to the fire when necessary, and to stand up in defense of the Association's core values. But the Commonwealth approach generally is not to publicly name and shame, not to use megaphones to chide and to rebuke, but to engage quietly, to agree on the shared objectives and then provide support in achieving those in partnership. That is the Commonwealth way. It has made a difference over the years, and it remains the best way forward. Thank you.
Thank you very much, Amitav.
Thank you, Madam Chairperson. I hope everybody can hear me. I'm sorry, I have a bit of a cold at the moment. I will be gentle to a certain extent, Amitav. I've taken on board what you've said, but I may also have some other differences of opinion. One of the greatest assets of the Commonwealth has to offer is the agreement by member states that to the Commonwealth fundamental values, which include the highest of standards of good governance, the rule of law, and the protection of human rights. The Commonwealth is a free association of independent nations and has been, and that has been seen as an asset, as moral pressure can be brought to bear on countries which has not seemed to be complying with the commitments and their commitments in relation to the democracy and human rights. As we've heard from Amitav, the Commonwealth was the first organisation to create a Commonwealth Ministerial Action Group and with the right to suspend and potentially expel members. And for a time, these highest of standards were not an aspiration, but were a reality because the moral pressure was there, and the mechanisms, including the use of the Secretary General's good officers and special envoys, were very effective. But we can no longer rest on our ancient laurels of the fight against apartheid in South Africa or the suspension of military governments who do not comply with the Commonwealth fundamental values. We led the way in these initiatives, but are very much in danger of being seen to be irrelevant if we do not reinvigorate this process that we have put in place. In preparing for this meeting, I looked at a speech given by Sir Sonny Randhawa, former Secretary General of the Commonwealth in 2005, to celebrate the 50th anniversary of the Commonwealth Law Conference. During that speech, he mentioned that the UK Prime Minister Sir Anthony Eden, during the opening ceremony of the first Commonwealth Law Conference in 1955, said we must not take too much for granted, that what our ancestors won by effort can only be kept by vigilance. We have all of us, and my emphasis is Anthony Eden's, our respective parts to play. That is true in our economic and political life. I think it is equally true in the law. It is because millions of people in all our countries believe that by and large the law upholds fair dealing and equity. It is because they believe that there is respect for the law. It is this respect which inspires the Commonwealth to go forward as a strong and steady force in the world affairs. Unfortunately, the last three reports to the by the Commonwealth Latimer House Working Group, which monitors compliance with Commonwealth fundamental values and the Commonwealth Latimer House principles in particular, have highlighted the increasing disregard for Commonwealth fundamental values by all member states. And nobody is, as Senator Segal mentioned, is immune. In his speech in 2005, Sir Sonny Randhawa pointed out that instead of going forward to a new era of global security that responds to the law and collective will and common responsibility, we are going backwards. There should be no question of which way we go, but the right way requires the assertion of the values of internationalism, including the very special primacy of the rule of law worldwide and institutional structures that secure and sustain those values. And the situation has not improved in the last 8 years. In the CMJ submission to the Commonwealth Secretariat's Eminent Person Group in September 2010, we said the Commonwealth has been a leader in the promotion and implementation of good governance, human rights and rule of law, but its institutional capacity has yet to match its intentions. At their meeting in Perth, the Commonwealth Heads of Government did consider both reports, the EPG and the CMAG report, as was reported earlier. The EPG report recommended that there should be a Commission for Democracy, Rule of Law and Human Rights to provide well-researched and reliable information simultaneously to the Secretary-Generals and Chairperson of the Commonwealth Ministerial Action Group on serious and persistent violations of democracy, the rule of law and human rights in a member state, and to indicate approaches to remedy this action. The CMAG report was on how they could strengthen their own processes. Whilst the idea for the Commission for Democracy, Rule of Law and Human Rights is still being hotly debated, as we've heard, the recommendations by CMAG were strengthened and were endorsed by heads of government. But all these mechanisms need to be strengthened even further. In May 2010, the CLA, Commonwealth Lawyers Association, Commonwealth Legal Education Association, and Commonwealth and our organisation, the CMAG, made a submission on the future of the CMAG itself. This was done in their capacity as members of the Latimer House Working Group. Some of these recommendations have been taken on board, and we welcome these recommendations, such as the mechanism for rapid response, with CMAG meeting virtually if required, and this was implemented earlier with the crisis in the Maldives, following the legal detention and arrest of the Chief Judge and subsequent demonstrations in the Maldives. However, whilst it was rapid in CMAG terms, from the time the former president was allegedly removed from gunpoint from office, the judge at the heart of the problem had actually been in detention for 4 weeks, and the CMJ had been in contact with the Secretary-General and the Commonwealth Secretariat on a number of occasions before the Commonwealth decided to send a mission to the Maldives to investigate the situation. The ministerial mission only came after the gunpoint the president was forced to resign. CMAG's membership consists of eight foreign ministers from Commonwealth countries and a representative of the country of the chairperson in office. The Latimer House Working Group suggested that there should be a mechanism in place for a minister to recuse himself, and I'm glad to say that the Maldives does not currently sit on the group, as its membership has been placed in abeyance until they are removed from the formal agenda. But the suggestion that another foreign minister should take their place has not been taken on board. I mentioned in particular the removal of the former president of the Maldives at gunpoint for a reason. The mandate of CMAG clearly states that it should be dealing with serious and persistent violations of the principles contained in the Harare Declaration. There may be benchmarks, as mentioned by Amitav, but a number of organisations, including the CMAG and the CLA, have expressed concern that the mandate continues to be interpreted too narrowly and focused too much on unconstitutional overthrows of government. Although CMAG has a wider brief, it continues to interpret the role in a conservative manner. CMAG should examine persistent violations in countries that purport to practice democracy, but where in fact the rule of law is being manipulated to suit the current political incumbents. I mentioned in passing member countries such as the Gambia and Sri Lanka. Some may recall us I raised the issue in this very building earlier this year about the situation in Papua New Guinea. In our view, the dispute over the Prime Ministership there at the time, the sacking, reinstatement, resacking, reinstatement, resacking, and arrest of the Chief Justice, finally arrest of the Chief Justice, and the passing of a law that gave Parliament carte blanche to suspend any judge deemed in its eyes to be biased, was a blatant, persistent and serious violation. But many may recall a comment made at the time by one of the participants that there was no reason for CMAG to look at this because the soldiers had stayed in their barracks. Fortunately, the situation has resolved itself since the election. This has mainly been due to a very strong judiciary supported by very strong international legal and judicial organisations outside the country. This is not what we want for the future for the Commonwealth. People may say that there is no way we can assess a violation as serious and persistent. At the moment, that is correct. Whilst there have been some discussions within CMAG itself, there is to date no specific attempt to assess the implementation of Commonwealth countries' commitment to its respective commitments to democracy, governance and human rights. We don't want to place additional burdens on member countries, but it should be recalled that the Latin House Guidelines on Parliamentary Supremacy and Judicial Independence of 1998 proposed in Chapter 11 that an effective monitoring procedure should be devised that all Commonwealth jurisdictions accept an obligation to report on their compliance to all ministers and heads of government. At a joint colloquium on the Latin House Principles held in Edinburgh in 2008, the participants offered the Commonwealth Secretariat help by establishing a standing committee for the purpose of gathering relevant information, reporting on the implementation of principles, best practices and areas of concern to inform the deliberations of the ministerial action. They also encouraged other civil societies to assist in the gathering of such information. We had hoped that this role would be fulfilled by a Commission for Democracy, Human Rights and the Rule of Law, but until the establishment of such an office or of any other form or mechanism in which we can provide this information to CMAG or to the special envoys, it continues to fall to Commonwealth associations like ours to keep checking what is happening around the Commonwealth. Although, as we say, there is absolutely no formal mechanism at the moment to present our findings or the findings of other civil society organisations to the Secretary-General and to the chairperson of CMAG. So what other mechanisms are there? The Secretary-General can use his good officers and appoint special envoys, but the latter are not always given the terms of reference that include a holistic examination of all aspects related to governance. More often than not, the impact of violations of the Commonwealth principles on the health of the judiciary does not feature in any terms of reference, and yet an independent, qualified judiciary is essential to upholding the Commonwealth principles. And as we saw in Fiji, it was one of the reasons why the coup happened in Fiji over 6 years ago. Special envoys should meet certain criteria and have certain basic skills. They should be seen to be independent and have the right qualifications and training and understanding of the separation of powers and the Commonwealth fundamental principles, and be required to hold briefings with relevant Commonwealth associations before they undertake tasks, or even during their discussions. At the present time, no discussions have been held for the special envoy, especially with Commonwealth organisations on the Maldives, for example. We have, even though we have volunteered to help out. We have already mentioned the lack of involvement of civil societies in the CMAG process. The Commonwealth network of associations and civil society organisations should be recognised as an important early warning system in areas of potential breaches. We do play our role, Amitav. We try to play our role. Although accredited Commonwealth associations try and keep political and legal affairs division of the Commonwealth Secretariat informed of concern, there is no formal mechanism for these associations to report on issues to the Secretary-General or to the directors of the Political Affairs Division or the Legal Division. And the feedback that we receive when we do report is very irregular and uninformative. Without a strong independent judiciary and independent legal profession, freedom of the press, there can be no vibrant human rights environments. It is over 30 years since the Harare Declaration stated that the Commonwealth member states believe in the liberty of the individual under the law, in equal rights for all citizens regardless of gender, race, colour, creed or political belief, in the individual's inalienable right to participate by free democratic processes in framing the society in which he or she lives. The Commonwealth Secretariat has come under criticism for not being proactive on the human rights front. The Secretary-General has indicated that his hands are tied sometimes by the Commonwealth governments. But bowing to the will of kings or heads of government who do not have any respect for the Commonwealth principles, such as Swaziland, and there has been criticism of his recent visit to Swaziland, that deliberately flout the international human rights norms is not an answer either. Every year we get an update on the status of human rights in the Commonwealth from the Commonwealth Secretariat. But this report is limited to which country has acceded to which treaty, ratified which treaty, signed which treaty. It doesn't go into the practice in each Commonwealth country, and human rights, like other rights, have been eroded over the last few years. I want to only to mention two recent examples of the way in which human rights are being eroded in the Commonwealth, and as an illustration of the problems we face. Amitav mentioned the issue of the executions in the Gambia in August this year. This was the first time that Gambia had executed prisoners in 27 years. The death penalty, which had been previously abolished under the former regime, was re-established after the coup that brought President Jammeh to power. When the international community has been calling for the abolishment of the death penalty, a Commonwealth country is going in the opposite direction. Yes, the Gambia has now suspended the executions, but that does not guarantee that they won't proceed in the future. President Jammeh has made it quite clear. The Commonwealth did issue a statement on the 28th of August condemning the executions, but this may be too late. The CMJ and others have been calling for Gambia to be CMAG for years for the serious and persistent violations of human rights there. Press freedom is no longer a possibility, and the independence of the judiciary. How many editors have to be arrested, their newspaper premises burnt down, lawyers imprisoned, chief justices sacked, people executed before the Commonwealth takes any action? Last week, some of you may have read that the President of South Africa, President Zuma, speaking at the opening of the National House of Traditional Leaders, said Africans had their own way of solving their problems through traditional institutions. Let us not be influenced by the cultures that try and think that lawyers are going to help. Well, you may have different opinions about whether lawyers can help or not, and I'm not going to go into that. But for those of you who have not been following the progress of the Traditional Courts Bill in South Africa, let me elaborate. The Traditional Courts Bill would create a separate legal system for 18 million rural South Africans. The Traditional Courts Bill, as currently drafted, would allow chiefs in traditional societies to be the judges in legal disputes amongst residents within their jurisdictions. Supporters of the bill say that this will free the existing judicial system, reduce delays, increase productivity within the administration of justice in South Africa. But the rights of women, children and other vulnerable members of society would be put in jeopardy, as the bill, as currently drafted, does not allow for these vulnerable individuals to choose which court to go to. It doesn't also allow them to have legal representation. As the judicial officers in these traditional courts would not be legally qualified, the existing qualification requirements for judges and magistrates in South Africa do not apply to them. Everybody knows that these patriarchal traditional societies are not necessarily aware or open to the idea of women's rights and the rights of other vulnerable members of society. But South African citizens, like all Commonwealth citizens, have a right to a fair trial and have the right to equality before the law. And South Africa has a duty to abide not only by the Commonwealth commitments, but its international commitments. I've deliberately, due to time, not mentioned the current situation in Sri Lanka, as I'm aware that this is going to be discussed tomorrow. Needless to say that we are monitoring the situation in Sri Lanka, and the recent attempts to impeach the Chief Justice on spurious charges has not helped the image of the future host of the Commonwealth Heads of Government meeting, or to project the Commonwealth as a strong promoter of political and human rights. The CMJ has played their role and is currently playing their role. At the last CMJ Council meeting, the Council expressed concern that the stronger action has not been taken by governments to ensure that Commonwealth Latin House principles are being respected and adhered to by governments throughout the Commonwealth, with particular reference to the independence of the judiciary and to the Commonwealth, to the principles included in the Latin House principles. The CMJ has been tasked to take appropriate measures to ensure that the Commonwealth Secretariat continues to promote adherence to that aspect of the principles and to maintain the momentum that was noted by the Commonwealth Secretariat General at the colloquial meeting in Edinburgh. In his book, The Lawless World, in 2005, Professor Philippe Sands pointed to a world that was moving backwards when it came to the respect for international laws and principles. The Commonwealth has not been immune to this backward direction. The Foreign Affairs Committee's report, that was published today, says that they heard disturbing evidence that the badge of respectability has become tarnished, and the Commonwealth's vestures as a promoter of democracy and human rights in its own member states are behind us. We don't want that to continue. The Commonwealth works on the basis of consensus. Unfortunately, people of the Commonwealth do not have consensus when they are faced with undemocratic practices, abuse of power and disregard for human rights. We want to avoid going through a Commonwealth spring to re-establish the democratic principles, so the Commonwealth has to be stronger than it is currently. Thank you.
We've had a view from the inside and a view from the outside, and over to Purna, who I think will be settled too.
I'd like to stay here, please, if that's okay, as I have sort of, as usual, rewriting what I'm going to say as I go along, so I've got about 600 bits of paper I might call on. I do want to say most importantly, we should acknowledge the state of close of play today, 323 to 4, those who are keeping an eye. Okay. Yes, Daisy, I straddled both in a way, and for those of you who don't know, I was head of human rights at the Commonwealth Secretariat for almost 4 years, leaving there last year. And so I want to speak both with the voice of somebody who has a particularly soft place for the Commonwealth. That's why I went to work there. I also have a personal reason for going there. My grandfather worked in Nehru's office and was with him when he was involved in negotiating and talking about the setting up of the Commonwealth. So it's a very personal commitment for me. On the other hand, I left in massive frustration. So I said to Daisy yesterday, I could actually read you my resignation letter from the Commonwealth, which will tell you a lot of what I want to say about the difficulties around working around human rights, but I don't think that'll be enough. What I'd like to do is speak as a critical friend, and I think it's friends who really need to be listened to rather than enemies, of the Commonwealth, and offer both an organisational and an institutional analysis of why the human rights work is so difficult, and why I have queries about reform. Where to start? I have so many different notes I'd like to start with. I think we do have to acknowledge that there is mounting criticism of the Commonwealth, and I think that's been said in the room. And there are accusations of irrelevance of the organisation. But I think there's also some evidence of hope and faith and aspirations around democracy and human rights work that the Commonwealth could and should be doing. The Commonwealth conversation that took place a couple of years ago showed how much interest there was, how much popular interest there was in the Commonwealth promotion of democracy and human rights. And those sorts of interests and aspirations have been reflected in the words of some member states themselves. As I say, I believe very much in the potential of the Commonwealth, and I had a great interest in working with governments. I don't come here to criticise them unless they're doing something that needs criticising. Not here for the sake of it. So let me start with a few comments about organisational issues and then institutional issues. But my opening comment, I think, must be about the need for courage and boldness if you're going to be serious about human rights. Human rights work is not about maintaining the status quo. It is not about keeping people in power and authority happy. It is about delivering a lived reality that respects and upholds and promotes the dignity of every human being in this world. And I think some of the Commonwealth conversations that we have, the discussions that we have, forget that we're about people and not just about states. So I'd like to have that into more centrally into the discussion. Organisationally, I'm sorry, Amitav, I'm going to say something you've heard me say many times, and Shana, you already look pained, it might get worse. The human rights team of the Commonwealth Secretariat does not enjoy the status of other areas of work. So let's look at the structure. It is a unit. It has progressed from being a small team within political affairs to legal affairs and to now being a freestanding unit answering directly to the Deputy Secretary General. That is progress indeed. But political affairs is a division. Economic affairs is a division. I'm not going to think of legal affairs, a division, and so on. And they're headed by directors. The human rights team immediately, structurally enjoys a lower status. And I think that's a pretty clear signal. It's a pretty clear message. It doesn't take a lot of work to interpret what that means. Allied to that is the tragic paucity of resources given to the human rights work. When I arrived, this number reasonably well because I kept saying it to everybody about how dreadful it was. The Human Rights team had £225,227 to spend each year. Now you look at some of the other divisions, or some of the divisions in the Secretariat, they have millions of pounds. You can see where human rights priorities are within the Secretariat. But let me talk to you about, no, it's not racism, but I will say something about race. I'll come to that in a minute. I don't think it's about racism. I think it's actually about my next point, which is the toxicity of human rights within the Commonwealth. Let me give you an example. The word most often used, I found, when I was trying to raise human rights advocacy work and do things that hadn't been done before in the Secretariat, was the word sensitive. Human rights work is sensitive. Death penalty is a sensitive issue. LGBT rights is sensitive. Looking at women's rights in marriage is very sensitive. And sensitive is almost a code for taboo. We don't do something that's sensitive, we don't do something that's difficult. I'm characterising, but only, I'm caricaturing, but only slightly. And let me give you an example of this. At one point, I think it was possibly a year or two into my term at the Secretariat, we had a conversation with the gender team about joining our work, because a lot of their work was about women's rights, and ours was also about rights. Let me tell you, it's not a verbatim quote, but a substantive quote that was put to me by the gender team. Now, their director was very sympathetic to our alliance being more strongly formed and structurally embedded. What I was told was that the gender work has a long and respected history in the Secretariat, and it does very well with states. Of course, there's a massive commonality and interest in areas of work, but if we called it human rights work, nobody would work with us anymore. We would lose all the goodwill, we would lose all the cooperation that we get from the states, and so we're not prepared to go there. I think that tells you a huge amount about how human rights is seen. I think there's a massive discomfort felt personally by many staff at the Commonwealth about doing human rights work, as evidenced by that. I'm not going to name names, I don't think that would be fair. When the Uganda anti-homosexuality bill was first mooted in the country, there was obviously a lot of kerfuffle in the building, and it was agreed that we would go and talk to the High Commissioner. I won't divulge any conversations, it would be inappropriate. But what was very interesting was how reluctant my colleagues were to come with me in that meeting. One of the reasons offered was, we have to work with these states on other issues. Somebody said I have to go home to Uganda, so I can't upset my government. And what we did was, two of us in the human rights team and nobody else from the building went and had the conversation about the bill, which I must say actually doesn't criminalise homosexuality, which is already criminalised. What it does is it adds, I'm sorry, it's not homosexuality, it's homosexual acts. What it does is, in its initial version, it imposed a death penalty for those who were found guilty. It criminalises those who know of those who are homosexual and don't report them. And very importantly and under-discussed is the fact that the bill withdraws all human rights international commitments that Uganda has already made. It's a massive deal. Anyway, I think that sort of demonstrates how difficult and how isolated the human rights work within the building. There's also massive reluctance to act. When Jana, you already talked about Jana Karen, when he talked about killing all human rights actors in his country, President Jana did this in 2009, he said, I was pushing for us to be responding somehow, but what I met was objections that said, no, we don't know that he actually said it. We have to get the television transcript before we can do anything. Now, you can argue for that in terms of rigorousness, but I think it's rather more procrastination. And I don't want to condemn my colleagues for it, because I know it is really difficult, and that's why I say you have to be bold, you have to be courageous to do human rights work. And an institutional issue that relates to this in a minute. On Sri Lanka, there's so much to say, but I won't say a great deal. What I will say is just to give you by way of example, as the war was nearing its very bloody finale, the Secretariat started to put out some press releases on concerns. And having seen how things worked in the building, I had tried to add into the sentence that said something like, the Secretary-General expresses concern about the deteriorating human rights situation in Sri Lanka. I thought I'd add something very mild, and that was, and human rights in that sentence. It didn't fly. It didn't fly. I spent 2 years in the Secretariat consulting on and drawing up a human rights policy for the organisation. It was cleared through all the staff. We consulted every division. We went through senior management group, I don't know how many times. They're probably very bored of discussing it, but it had massive buy-in. I left it on the desk of the Secretary-General just with the signature. I don't know where that's got to. That perhaps we can be updated on that. I want to return to two of the most contentious issues in the Commonwealth, which have already been mentioned. One is the death penalty, and one is LGBT rights. Karen, you're quite right to say that the status report, which didn't exist until I went and started it, that it does talk about ratifications and accessions and so on. But we didn't have this before. And I can't tell you that it was easy to get. But the second edition, I have to say to you also that I was told when I first proposed it that it wouldn't get through the Publications Committee because there wouldn't be support for doing something as bold as naming what every country has done, which is all public domain facts. It's nothing new. But what we did do is we stepped further in the second edition in 2010 and included the death penalty, which hadn't been done before. So if any of you get hold of this publication, you'll see at the back some graphs and charts. And for the first time we did a review, a little survey of every country's position on the death penalty in the Commonwealth. And I got quite a bit of flack for it. I won't name countries, but you can work it out. Countries that are known internationally for the promotion of the death penalty objected to this publication, objected to any discussion of death penalty, saying it was not a human rights issue. And I was called in to see the Secretary-General to be told this. He didn't stop me from doing it again. He didn't stop me from talking about the death penalty. But it was very clearly, it was made very clear to me that this was a problematic area and it would cause problems were we to continue to do that. It's very interesting that the diversity of the Commonwealth is often posed as a problem in terms of acting together. I have real worry about diversity being used as a cloak for inaction. Very problematic. I think our skills in diplomacy, and Amitav is one of the most skilled, is about negotiating that difficult territory. And I also look at other organisations who have done this, like Francophonie, which also has members who execute and those who don't, but has taken a position against the death penalty. So what it has signalled is its commitment. And it has told its members this is where we're going to go. I'm not sure why we can't do that. I also think there's a slight problem about the coverage in our work. And this, I think, is the elephant in the room. We don't work on the ABCs. We're all insiders, we know what we're talking about. We don't work on the...
Can you explain ABCs to those who don't know?
Oh, I thought we would, okay. The richer countries that contribute most money to the Commonwealth, Australia, Britain, Canada, who else? New Zealand, the major contributors. I was told very clearly when I started at the Commonwealth, we don't do human rights and work in those countries. But, and this now moves us into the institutional discussion, but if our conversations exclude some countries from view of international standards and values, then our conversation is extremely biased and problematic. And the problem is partly that our conversations are flavoured with colonial and post-colonial power relationships, and we don't talk about it. And the problem then is that it becomes the Secretariat, majority paid for by the richer countries, telling the poorer countries what they should be doing. That's not helpful, nor is it a true, genuine upholding of international standards and values that the Commonwealth espouses. We ought to have been able to talk about the UK move for massively unbelievable periods of detention without trial. We weren't allowed to do that. We ought to have been able to talk about police killing of civilians, which happened here in the UK. We weren't able to do that. I asked at the time, why don't we do training with the police in the UK as we do in other countries? No, we don't do that. So I think the Commonwealth does itself a disservice by failing to hold people to account to the same standards. In terms of institutional arrangements and impediments, by which I mean the rules of the game, there are some things that make it difficult for the Commonwealth to do more. The recruitment policies, which tend to favour civil servants from member states, mean they have an eye to what happens when they go back. And as I said, their agenda is to keep a clean chit when they return home and take up positions with their government. So that must be an inhibition on what they're prepared to do. I know that some people complain about the leadership of the Secretariat, and I think they're in this room too. But I don't think a change of leadership is a solution. This is not a total solution, for those who think it is part of the solution. I think there is too much of an institutional inertia. The leadership is appointed by the board. The board wants this type of leadership. The board has been burnt by leadership that's perhaps more active and more critical. And we have to think about what the role of the Commonwealth is in terms of advocacy and leadership in the international stage. Whether we want a staid, conservative organisation, or whether we want one that's leading in the world. And I've talked about the process of poison and diversity as a potential inhibition. Another rule of the game is that the Secretariat works in a responsive way. Now what this means is that for human rights work, we wait for governments to come and say we'd like to improve our human rights work. Well, those who are not terribly committed aren't going to do that. As Amitav said, the Secretariat doesn't have an investigative or monitoring role because the UN has it. But the UN also has a technical support and advisory role, and that's allowed for the Secretariat to do. But the more problematic investigative and monitoring role is seen as somehow a step too far. I do think that's a problem. It needs reviewing, it needs discussing. So, but if a state is not wholly in support of the values of the Commonwealth or fully implementing them, they can carry on doing that. And related to that is an issue that technical assistance offered by the Secretariat continues no matter what. We provide judges to Gambia in the context of judicial interference. We continue to work with Uganda no matter what happens to their bill. We continue to work with other countries where women are flogged, where children are not at school, where child labour is massive, and the technical assistance is not questioned. It's said so many times that silence is not an option, but it is, and it's the option that's preferred. It's a fact. And it has certainly been a preferred option on human rights. I've sounded extremely negative, but I'm glad I put that positive point at the front. I'm saying it because I think the Commonwealth can do a huge amount more. Possibly the proposals around a charter and a commissioner might help, but I think there are institutional matters that also need addressing. What's the role of the commissioner vis-à-vis the human rights work of the Secretariat? Is it a substitute? Is it an addition? Does the human rights team answer the Secretariat or the commissioner? Do they have complementary or distinct mandates? Does the resources of the human rights team move to the commissioner? None of those questions have been answered to my knowledge. And whether or not the commissioner is a good idea for me depends on a lot of those details that we don't have. A charter might be great, but we do have an affirmation of principles and values that were made in Trinidad, 3 years ago. Task surely is implementation. We can spend thousands or millions of pounds and who knows how much time agreeing a new charter, which perhaps can go into schools and be displayed. But what do we do about it? What difference will it make? That's the challenge. The challenge is action, not just words. I have to end. Daisy's looking at me and I said I wouldn't go on too long. Is reform possible? I don't know. Is reform necessary? Yes. I bumped into somebody, a former colleague at the Secretariat this morning on my way in, and I said, I'm going to this conference looking at reform of the Commonwealth. And that person said to me, it's way too late. It's way too late. They're still there. They weren't there. way too late, it's not going to happen. And all the good people are leaving because they don't see it happening. I think that's an absolute tragedy if that's the case. I think the Commonwealth is perhaps a little too comfortable with itself. And I think it needs to be more creative, more innovative, more bold. As Ron Santos has said, that the Commonwealth may limp along for a while longer, but it will surely lose its influence within its own members and the wider international community in which it's played a role in the past. Today, the UK Foreign Affairs Select Committee report, its opening sentence reads, "The moral authority of the Commonwealth has too often been undermined by the repressive actions of member governments." And that, I think, reminds us to think about who they're repressing. If our work does not make a difference, I'm going to read you something else, I can't remember. Well, our work cannot make a difference to the children, the women and the men of the Commonwealth in improving the quality of their lives, the way in which they deal with governments, the way in which they hold their states to account, the way in which states deliver their obligations they make on the international stage to their people, then we're missing.
Thank you, Connie. We now have 20 minutes for questions. Can I see a show of hands to see how many questions there are? Okay, we'll start at this side and we'll work our way over. So I'm going to start with Stuart and then move to Bala and then we'll keep moving round. So Stuart,
thank you very much, Stacey. My thanks to all the panel, but particularly I think to Amitav, since very much in the firing line here, Amitav, and as a former colleague of yours, I want to attest to your professionalism in all matters, and I have the highest regard for you. But now, of course, I want to take issue with quite rightly, you question whether there is a crisis, and are we right to consider matters today in November. And I want to address, just to ask you to comment on Sri Lanka in that respect, because we have the Foreign Affairs Committee report today. It says the decision to hold the Chogam was wrong. It also says that the British Prime Minister should not attend unless there have been significant improvements along the lines that we all know are expected. We also know that's the situation with the Prime Minister of Canada. So, when heads of government threaten not to turn up to meetings, then that is, I think, an evidence of some measure of crisis. Now, you said that in terms of CMAG's enhanced powers and the Secretary-General's enhanced role, good office's role, that maybe a challenge, the serious challenge, had not yet arisen. I haven't quoted your exact words, but I think that's what you said. But maybe Sri Lanka is one of those serious challenges that either is being addressed privately and we need to know about, or isn't being addressed. And of course, there are sort of firm grounds on which the Commonwealth can and indeed should address those issues. The whole process of the international community in terms of the lessons learned in the Reconciliation Commission in Sri Lanka, but also its own observer group report of 2010, which showed there was indeed a democratic deficit. Now, either the Commonwealth is not showing us that things are happening in terms of good offices, in which case it's a communications issue, which wouldn't surprise me, or, in fact, there is not a sufficient good offices exercise going on. And I wonder, Amitav, if you could address that.
Thank you, Stuart. We are going to take a group of questions this time round. So Bala next, and Terry. So Bala, if you could introduce yourself and ask a brief question.
Okay, this is a question about the role of civil society in relation to CMAG's new powers. As a member of the Civil Society Advisory Committee of the Commonwealth Foundation, we did be here and just mentioning some discussions that took place in relation to CMAG, whether civil society organizations and feedback could be used proactively by CMAG rather than waiting for a later stage. So is there a structural mechanism in which civil society organizations, whether they are in the judicial area or whether they are in the executive area or whether they are in the legislative area, associations in all the areas. So whether this can be more proactively used by CMAG, and if there is anything, if you can let us know.
Great, thank you. Please introduce yourself, please. If you could introduce yourself to the principal.
My name is Terry Dorman. I worked for 32 years at the Commonwealth Secretariat, having previously served some years in Uganda and some years in Nigeria during the Civil War. Is reform possible? I definitely think that it is. Is reform necessary? I definitely think that it is. All organisations are in constant need of reformation. The Commonwealth stands for a broad range of magnificent principles, and all of us who have served in the Commonwealth in any capacity, I'm sure, have always been much more excited because of our idealism by its potential than by its actuality.
Terry, could I push you for a question, please?
Yes, indeed. My question comes at the end. Understandably, our idealism and our commitment to the Commonwealth leads to us to make tries of corruptio optimi pessima, or as Shakespeare would put it, lilies that fester smell far worse than weeds. I think it is absolutely splendid and heartening that the Commonwealth should be under constant criticism, but that is an indication of how committed we are to the organisation. Does the panel agree?
Thank you very much. A question over here, and then a question, this gentleman here, please.
Yes, my question. How many members of the Commonwealth Magistrates and Judges Association are black or non-white in terms and what systems are in place to protect black and non-white members of the Commonwealth Magistrates and Judges Association from white supremacist racists?
I'm detecting a pattern here. Thank you very much. A very quick question from the lady here, and then one here, and then perhaps even come to the panel for the whole range.
Just one point, though I can challenge everybody to talk about Mr. Banerji said. The one point is CMAG. CMAG has a stipulation that any member can have 4 consecutive years. But Sri Lanka, while bloodbath was going on there for years of area bombing and intelligence going on there, it held up to 2009. It held 6 years. That speaks of the Commonwealth.
Thank you very much for that conclusion. Gentleman here, please introduce yourself.
Yeah, Madam Aval, British Towns Forum. So, Mr. Banerji, could you elaborate on what you said about the MOU signed between the CMAG and the ICC, please?
Okay, and Patsy, very quick question, please.
I have a question. I'm a bit confused. We talk about the Commonwealth when really you should be talking about the Secretariat. As far as I know, Commonwealth leaders have set certain principles. The body which should be carrying it out is the Secretariat. Now, if the Secretariat is not doing it, you can't really just say the Commonwealth is not pursuing what it should do. They have said very clearly we are against racial, religious, sexual prejudice. That's the first question. The second question about human rights, and I think Purna put her finger on the fact that no challenge is made of human rights violations, not only in developed countries, but nobody will ever challenge India on its human rights. The scheduled caste, people still in India suffer immense human rights violations. Because you tend to accept that India is a democracy, the bona fide of Indian government. I'll tell you what I say. When we went to Australia for a history, high degree of apartheid, shall I call it the first Australian, the original owners of the Australian continent, they came in their thousands to Melbourne to plead with Sonny Ramaphosa. Why is it you're taking up Africa and you will not do anything for us? We have suffered long than people have Malcolm Fraser was then Prime Minister. Commonwealth was abused the length and breadth of Australia for these people coming and spoiling the big show they had put on. The chap who owns all of Western Australia wrote to the Melbourne Herald what we should do is go back and poison their water. Malcolm Fraser said to Sonny Ramphal, "You've got to believe me, we will do something." Sonny Ramphal told those people, Australian government has the rule of law, and you do something about it. He lost the election, nothing was done. They were still suffering a lot of problems. So, when you say about human rights, how many Commonwealth countries really have a serious human rights record that they are not acting on? I could go on, but I think I have enough questions.
Lovely, thank you very much, Patsy. So, just to recap very quickly, a question from Stuart about Sri Lanka and his not wanting to go into a crisis. A question from Bala about civil society and how they present information to CMAG. A question from Terry about how committed are we with the Commonwealth. A question for on the Commonwealth CMGA and about your membership and representation. A question on Sri Lanka and CMAG, a question from Nad on the MOU between CMAG and the ICC, and then two questions from Patsy on discrimination and challenging India. I'll start with you, Amitav, and then or maybe I'll start the other way around. Maybe I'll start with Purna and then work this way down the table. So,
okay, I think I already answered your question when I did my talk about whether or not I'm committed to the Commonwealth. I'll let others speak for themselves. On Patsy, your point about the Commonwealth versus the Secretariat, that was my analysis. My first analysis was the Secretariat. The institution one was about the Commonwealth, the rules of the Commonwealth again. And that's what we mean by institutions, and that's what I was talking about. So yes, we do need to distinguish, and we need to talk about, and that's what I'm saying before, the Commonwealth itself appoints the leadership and chooses the way in which it wants it to be led and governed, which is why I don't think it's simply a question of changing leadership, it's about the culture of the Commonwealth and what we're looking for. India's problems aren't just scheduled castes. You have manual scavengers who clean up other people's feces with their hands. You have the largest number of child labourers in the world, the country with the largest number of child labourers in the world. You have, I just written an article around honour killings in India. The problems are huge. The good stories are huge too. That's the complexity of India. India's not the only country which the Commonwealth doesn't do a lot of work on in terms of human rights. I went there 2011 last, when we started to look at their work around disability rights and started to talk about whether we might work on some prison issues, conditions in prison. And that, I think, is a conversation that can progress. I don't know where it's got to now. But I do think there's an issue about which countries are less subject to scrutiny than others. But as I say, the methodology, the modalities of the Commonwealth, which is that the Secretariat responds to requests from members, then you can't undo that problem. You have to give the team at the centre some proactive authority. And I just want to say on racism, the Convention on the Elimination of Racial Discrimination has a poor ratification record in the Commonwealth. Africa leads as it does on many other issues, and for example, a number of human rights institutions set up. It has 100% ratification in Africa, but it drops down to 55% ratification rate in the Pacific. So I think that the story of apartheid, which is often used to assess the Commonwealth's credentials, is not a story about racism, and that work is still to be done.
Thank you, Purna.
Just one or two issues. In relation to the question that Patsy asked about whether or not we should be targeting the Commonwealth Secretariat rather than the Commonwealth. Yes, we should be targeting the Commonwealth Secretariat, but in many instances, like CMAG is led by Commonwealth countries. Those Commonwealth countries have been appointed by the Commonwealth heads of government as their representatives on CMAG. So it's not just the Commonwealth Secretariat that is at fault, it's the Commonwealth in general.
The Secretariat needs to be Secretary of CMAG. Are they not supposed to say this country should take over what's happening in this country?
As far as I understand the process, and maybe Amitav can actually elaborate, as far as I understand the process, it's the Secretary General and the Chairperson of CMAG that agree who should go on to who should be proposed for CMAG.
If you can say that.
But I mean, Amitav can. I think there is. I think what Purna says about the fact, or I think it was Stuart or somebody else who said that about the fact that there isn't enough publicity about the good things that happen. We don't know enough about. Yes, the Maldives, there's been a couple of things that have been in the press and in the statements that have been mentioned. But we don't get the good stories, and as Senator Segal said before, we don't get the good stories. We don't necessarily know. We don't get reports, we get regular reports. So maybe I am saying, maybe you have looked at the issue about the South African Traditional Courts Bill, or you may have looked at other things that we've been banging over the door to look at. But we are not aware of it. So therefore, maybe we're getting the negative view. And I am committed, Terry, to the Commonwealth. I wouldn't have been here for 25 years if I wasn't committed to Commonwealth and the Commonwealth fundamental values. And I think there is a great, we have a great opportunity. I'm enthusiastic about the Commonwealth. There are great things happening in the Commonwealth. But we just don't, again, the image of the Commonwealth, we can discuss this in other forums, is a negative image that actually has been portrayed. And I agree, I would like to hear how we can have this formal mechanism, the CSO involvement, because I think that is essential to the progress and to this reform of CMAG and good officers. Now, in relation to the question about the Commonwealth Magistrates and Judges Association, currently we have 67 jurisdictions in the Commonwealth. So all 54 countries and all dependent states of those 54 countries are represented. We do not have a questionnaire on whether you are black or white. All I can say is Nigeria is our second largest member, and on the council and trustee board of the CMJA, we have representation from all 6 regions of the country. I hope that's...
So you don't know, there's no information?
No information.
So it could be white supremacist racists?
Well, we hope that there aren't that many white supremacist racists in Nigeria, Bermuda, Barbados, and various other countries that are represented.
The whole Commonwealth?
The whole Commonwealth. I'm sorry, but we don't discriminate on the basis of race.
What evidence have you got?
No, I think you have had your answer, which is that there's broad-based membership of the CMGA, and those members come from right across the Commonwealth and of all backgrounds and all diversities, and we can take up anything else in the break. So to Amitav to answer some of the questions and any concluding comments.
Thanks very much. I think Purna started her remarks with the cricket score. I think I'll resort to cricketing terminology and say that in some situations it's very good to let balls go through to the wicket keeper, which I will have to do because I simply don't have the ability to answer every question that's been raised and don't also hold a candle for other parts of the Secretariat of which I have little knowledge. But I'll try and focus on the questions that have been posed, and beginning with Terry's, which is the easiest to answer and say yes. The answer to the question you posed is yes. I think we're all committed to the Commonwealth. That is why we are all here, and we want the Commonwealth to be working even more efficiently and even better for the good of all people of the Commonwealth. On Sri Lanka, and I know that this is not Chatham House rules, this was public and recorded, so I have to be careful in what I say. I will say to you with absolute certainty that we have been discussing issues with the government of Sri Lanka as the Commonwealth Secretariat in a very candid way for some time. And the concerns that have been raised are concerns that do matter to us. They matter to the Commonwealth because Sri Lanka will host the next CHOGM. We do keep saying that Commonwealth leaders in their wisdom collectively decided in 2009 to meet in Sri Lanka in 2013. In their wisdom, they collectively decided in 2011 once again that they will meet in Sri Lanka in 2013. We are therefore working with the government of Sri Lanka to organize a CHOGM. It is certainly a matter of interest and concern to us that the House of Commons Foreign Affairs Committee has now come up with a report that has also questioned the wisdom from a British Parliament point of view of holding a summit in Sri Lanka, and has called upon the British Prime Minister not to go unless certain things happen, following the example that has been set by the Prime Minister of Canada some time ago. I don't think it would be right for me to comment on what a British parliamentary committee says, or for that matter respond on what the British government might do. I think the British government has already issued a statement to say they've taken note of this and they will continue to monitor the situation. I myself haven't read the report in full, but it goes without saying that if a CHOGM is not attended by any leader for the reason that they choose not to attend, it is a very serious thing. Many leaders don't attend because they have elections or there are natural disasters in their countries or something else comes up. But, if there are leaders of the Commonwealth who take a conscious decision for reasons that have to do with Commonwealth values not to vote, we cannot but be concerned about that. I can certainly say to you that as a Secretariat, especially following the Secretary General's last visit in September, we have come up with a number of areas where we will work with the Sri Lankan authorities in terms of, for example, supporting the National Human Rights Commission, which is has been downgraded, I think, from A category to B for some time. Purna would know more about these things in terms of helping the Office of the Commissioner of Elections, but notably in terms of helping with the implementation of Sri Lanka's own Lessons Learned and Reconciliation Commission, which has come up with a number of recommendations, including in the area of reconciliation, where we believe the Commonwealth has a lot of experience. There are different Commonwealth countries that have been through conflict, that have been through post-conflict reconciliation. Some of those tools are very much borrowable and valid, even though every country's situation is sui generis. I would like, since I have your indulgence, to say that I spoke on a platform not far from here at SOAS, at an organization called at an event organized by the Association of Sri Lankan Professionals in the United Kingdom. I don't know if any of you were there, but the Sri Lankan High Commissioner was certainly there. And I just want to say that this is, among what I said, is the following. Winning a war is a far cry from winning the peace. The scars of war take long to heal, and they will never heal if the underlying feelings of alienation and marginalization are not resolutely addressed. And if every Sri Lankan, of whatever ethnicity or religion, does not feel that he or she is able to live a life of dignity and fulfillment in their own country, the wounds will also remain fresh if accountability is not established to the extent necessary and justice is not seen to be done. I then speak about the LLRC report and the importance of implementing them. I would also, I crave your patience, said the following. I read out what I said. There is no doubt that a lot is being done in Sri Lanka to rebuild conflict-ravaged areas and to rehabilitate those uprooted from their homes and hearths. The clearing of mines, the building of infrastructure, the resettlement of internally displaced persons, and the return of economic growth are tangible realities. At the same time, one needs to recognize that rebuilding and rehabilitation are not the same as reconciliation. The former involves providing homes and livelihoods. The latter involves winning hearts and minds. A durable peace will not come from building roads, hospitals and schools and generating employment. It can only be built on the foundations of providing political space and representation, the application of the rule of law and the protection and promotion of human rights. It requires appropriate devolution of political powers, empowerment of both the majority and the minorities, and, if I may exercise some license with Nelson Mandela's famous phrase, which Senator Seagal quoted, by making Sri Lanka truly safe for diversity. This is a message that is on our website, which was delivered in the presence of the High Commissioner and would have been fed back to Colombo. We've had fairly candid discussions with the Foreign Minister, the President, the Secretary to the President, who heads the task force on reconciliation, or on implementing the LLRC. The Sri Lankans do say to us that they feel double standards are followed, that in other countries nobody talks about human rights, but when it comes to Sri Lanka, there is a cacophony of calls for holding Sri Lanka to account. They also point out that all the other cases of reconciliation have been successor governments setting up bodies that sit in judgment on what predecessor governments did. This is the first example where a government has set up an investigation into what it itself did. It's not that sort of situation. It is an extremely complex matter, but I will not deny the fact that in the last 24 hours, from my point of view as the prospective Conference Secretary for CHOGM and as Director of Political Affairs, we have some new significant developments to look at. One being the House of Commons Foreign Affairs Committee report, the other being the report that has been published by the United Nations that talks of a systemic failure by the United Nations in the last days of the war. So these are issues that we will look at. Both of these reports have just come out. I haven't had a chance to study them. I can only say to you that Sri Lankans would know more than anyone else that a successful CHOGM requires good attendance. It requires an ability collectively to focus on issues that matter to the Commonwealth. And it does not help them if a CHOGM is held and the entire focus is on the domestic situation in Sri Lanka, of both the delegates present as well as the vast amount of international media that cover a CHOGM. On the role of civil society and CMAG, Bala, I did mention that one of the things that the Secretary General intends to do is to see how we can systematize this more. Karen also spoke about this. At the moment, there's nothing that prevents any civil society organization, CNJ included, and it does so, to send us representations on various countries, especially on the eve of a CMAG meeting, when it is known that CMAG is meeting. I think there is certainly a lot of merit in the suggestion that we can be proactive in engaging with civil society organizations that have a lot of knowledge in specific areas of Commonwealth values, and systematizing that consultation in the context of CMAG. That is definitely what we have in mind. And whether it goes to the extent of CMAG ministers meeting civil society, it's happened before on Nigeria in the mid-1990s. Ministers actually met a number of civil society organizations. It's for CMAG to determine. I would like to strongly endorse Batsy's point here that too often the Secretariat is seen as the villain of the piece. CMAG is 9 foreign ministers who take political decisions. It's not the Secretary General who takes the decisions that come out of CMAG. The Secretary General convenes CMAG. He can certainly recommend a country to be put on CMAG's agenda. I say he because there's not been a she so far. I'm not gender insensitive. There may be a she in the future, I hope. There is a process for consultation with the chair if the Secretary General goes down the route of recommending a country for CMAGing. The verb has come into the lexicon. But any member country can raise another country in CMAG. There's nothing that keeps a member country from doing so. At the end of the day, Commonwealth values have been promoted by the Secretary General as the elected Chief Executive of the Secretariat, most certainly, and by each one of us who work to him. But it's also to be followed up and espoused and promoted by the 54 governments that believe in the Commonwealth and that belong to it. I often ask how many presidents and foreign ministers mention one line of the Commonwealth in their speeches at the UN General Assembly, but they keep accusing the Secretariat of not doing enough to promote the profile of the Commonwealth. How many mention the Commonwealth in foreign policy debates in their own parliaments? But that's another matter. On the ICC, I will have to give you more detail. Jarvis, I don't know if you have any information to give about the content of the MOU, but I think it provides for cooperation and exchange of information, etc. Otherwise, there's certainly something you could send later on. Is there something you can add at this point?
Yes, I think the MOU is was drawn in the background that there are countries which have ratified ICC, there are countries which have not, but it takes into account those that have ratified and sort of want to see what sort of areas the two organizations may work together. And also work with countries which are intending to ratify but not so sure in terms of the regional dynamics that are going on in different parts of the Commonwealth. So I think it gives an opportunity to extend expertise and assistance in assisting countries which are members of the roster.
Thank you very much.
I should just mention on Sri Lanka, I didn't mention this, the move to impeach the Chief Justice of Sri Lanka, which Karan referred to, is also very much now a matter of public debate and discourse. We have been in touch with the government of Sri Lanka about it because concerns have been raised with us by the Commonwealth Magistrates and Judges Association and indeed by our own Legal and Constitutional Affairs Division, because while the government says there are 14 charges against the Chief Justice, the whole issue is being projected as one of the Latimer House principles being undermined, where the delicate balance between three branches of government, that sacrosanct balance, is seen as being upset. And it has been questioned whether Parliament needs to immediately move to an impeachment procedure before going through judicial processes and mechanisms that may be available. So it's a matter that we are in touch with the government with. From a Latimer House perspective. Thank you.
Thank you very much. Thank you very much for your questions. Thank you very much to the panel. Please join me in thanking them, and then we will move to lunch.